Hi, this is basically a summary of all of the key points related to the basics of the arbitration process. So in this video, I'm going to be outlining, that is providing an overview of all of the important points that you need to know relating to the basics of arbitration. So yes, this is a video that is going to cover all of the basic points related to arbitration. So obviously this video is not going to include any details about any of these points, that is, there will be no commentary, no explanations at all. So if you are interested in the explanations or the commentary, then you can check out my other videos in the revision lecture series on arbitration. For now, in this video, I'm going to begin right away with the basic points relating to the arbitration process. So the first and foremost step obviously is the foundation of arbitration, that is the arbitration agreement. So the first step, that is, there should be a mutual agreement between the two parties, which we term as the agreement to arbitrate. So the parties can agree mutually not to submit a dispute to a regular court of law, but instead to submit it to one or more arbitrators. And therefore arbitration is based on an agreement, that is a contract between the parties, to refer a dispute between them to impartial arbitrators for a decision. Now, what is an arbitration agreement? Well, an arbitration agreement is simply as defined in the Act, that is Section 2, subsection 2. It simply means a written agreement, that is to submit present or future differences to arbitration, whether an arbitrator is named in the agreement or not. And now there is no need to discuss the timing point, that is the point that I discussed in another video. That is, it does not matter whether the agreement is concluded before or after a dispute has started, because that is going into detail and this video is dealing with only the basics. So if you're interested, watch that other video related to the timing issue, whether timing matters or not. Moving on, you have to mention, at least in outline, just mention the three classes, that is the three modes of arbitration that are included in the Arbitration Act. Let me emphasize very clearly that there is no need at all in a basic lecture or in a basic answer or basic essay or a basic presentation that you might be making on this topic. There is no need at all to go on and define each of these three classes. So it suffices, that is, it is sufficient if you just mention that there are three modes of arbitration, that is three classes of arbitration, and the three classes are as follows. So number one is arbitration without court intervention, number two is arbitration with court intervention, number three is arbitration in suits. Now, these were the very basics relating to the arbitration process in Pakistan. And moving on, there are some important rules relating to the appointment of arbitrators. And of course, there can be only one arbitrator as well, so it's best to just say that the rules relate to the appointment of arbitrator. However, there can be more than one arbitrator as well, as you will see in the rules that I'm going to discuss right away. So remember that there are 6 key points that you need to remember, as I have discussed in another video that is dedicated only and only to the discussion of the appointment of arbitrators. But in this video, we're dealing with all of the basics, and the basics include the rules relating to the appointment of arbitrators. So I was saying that you need to remember that in an exam situation, it is not necessary, as long as the question is obviously not of 6 marks or maybe more, then in that situation it's not necessary to list each of these 6 points. It should be enough, for example, if the question is of 5 marks, to list just 5 points. Any 5 that you remember are going to be okay. So I'm not going to say that one of these is more important than another point. So any 5 of these 6 points should be fine for a 5-mark answer, for example. Okay, so let's get into it straight away. Number one is that the number of arbitrators can be either 1, 2, 3 or even more, so there is no restriction. Number two, where the arbitration agreement does not specify the number, then in that situation the arbitration proceeding is going to be by a sole arbitrator. So sole arbitrator simply means a single arbitrator, that is only one arbitrator. And by the way, this is one of those implied conditions that is included in an arbitration agreement. So by default, if the arbitration agreement has failed to specify the number of arbitrators, how many arbitrators are there going to be? Just one. So a sole arbitrator means just one. Number three, is the rule that in the case that there is an even number of arbitrators, then what happens is that an umpire has to be appointed, obviously from among the arbitrators. But remember that if there is an even number, let's say there are 8 arbitrators, then obviously the decision is not going to be by majority, because if let's say 4 of them agree, that's going to be a problem, right? So just like in a case in a court of law, there are obviously always odd number of judges, either there are 3 or 5 or 7. So the bench is obviously always odd because of this very reason. However, there is a possibility that when people appoint arbitrators, they may appoint an even number of arbitrators. So the act, that is the Arbitration Act 1940, has already provided a solution for that sort of situation, which is to appoint an umpire, and that umpire's decision is then going to prevail. By prevail, by the way, in case you don't know, I simply mean that that umpire's decision is going to be considered final. Okay, let's move on to the fourth point. The fourth point is that an arbitrator may be named in the arbitration agreement itself. So if, for example, the parties are absolutely clear about who the arbitrator is going to be in the future, let's say it's a construction project and the parties are agreed about the engineer who is going to be the arbitrator in case there is a dispute relating to any of the terms and clauses in their agreement. So if they want, they can name the arbitrator in the arbitration agreement itself. That option is also available. However, you must remember that a related point, that is a point related to this fourth rule, is that this is not mandatory. That is, it's not compulsory that you have to name the arbitrator in the arbitration agreement at the time of concluding that agreement. So in a situation where you are not sure about who the arbitrator is going to be, then instead of choosing, that is selecting one particular person who is going to be the arbitrator in the future disputes that arise between you and the other party, then in that situation what you can do is you can stipulate in the arbitration agreement itself a mode of appointment. And by stipulating a certain mode of appointment, I simply mean to say that you can state a method, that is a way that is going to be adopted in choosing that arbitrator in the future. So in short, in other words, if you want, you may leave this particular situation to be decided later on. That is, the arbitrator may be appointed by some sort of designated authority, and you may state this designated authority in that arbitration agreement itself. Okay, moving on. Rule number 5 is very simple. This says that if the arbitration agreement is silent about the mode of appointment of arbitrators, that is, you have not mentioned the name of the particular arbitrator, neither have you mentioned a particular method of appointing that arbitrator, that is, the mode of appointment is also not included in the agreement, then in that situation, what happens is that later on, if the parties are divided on who the arbitrator is going to be, that is, when a dispute actually arises, then the parties are unable to choose one arbitrator and they are having a dispute about who the arbitrator should be in that situation. That is, the dispute has already started and they are not able to agree about the choice of the arbitrator, then there is a power that is given to the court to make the appointment of the arbitrator. Right, that brings me to the sixth point, which is very simple again, that not all arbitrators are going to be lawyers. So in short, there is no requirement that the arbitrator should be a member of the local bar, that is, that the arbitrator must be a qualified lawyer. Yes, of course, there are situations where arbitrators are also lawyers by profession, but this is not a requirement. So these are the 6 rules relating to arbitrators. This brings me to the end of this video. I hope you find this summary useful.